Hi, my name is Lisa Cummings, and today I'm going to share with you an overview of the IRS final regulations relating to catch-up contributions that are permitted to retirement plans. Before I do that, let me take a moment and share with you a little bit about our firm. Our firm is Cummings and Cummings Law. Our website is cummings.law. And we represent both businesses as well as individuals for full service legal support, including income tax planning and estate planning, with special attention to retirement plan. My name is Lisa Cummings, and a bit about myself. I have spent my legal career as an attorney working with large companies to support them as well as their employees in the design of retirement plans as well as health and welfare plans. Also paying attention to executive compensation programs. Now let's take a few minutes today to cover our topics that we'll be reviewing here shortly. First, I'm going to share with you the context of the IRS catch-up regulations and the effective dates. And then I'm going to be talking about the high earner Roth catch-up provision, which was outlined in our latest final regulations. Talk with you a few minutes about plan mechanics and deemed Roth elections. And then we'll cover our super catch-up group, which are aged 60 to 63 participants. Then we'll talk about any type of special cases with potential corrections, and then highlight action steps and conclusions for plan sponsors. So the context behind the most recent IRS final regulations relate to catch-up provisions to retirement plans. Now, catch-up provisions in and of themselves are not new. That was enabled with Section 414 of the Code. Those catch-up provisions allow participants age 50 and older to make catch-up contributions. However, what the final regulations did was they integrated the Secure 2.0 Act's Roth mandate and super catch-up. The final regulations were published on September the 16th. They will become applicable to contributions that are made in tax years beginning after December 31st, 2026. In the final regulations, the IRS shared with us some clear information about a high earner Roth catch-up. High earners in the final regulations are identified as those individuals whose prior year wages were greater than $145,000. For those individuals falling into that particular income bracket, then you will see that catch-up contributions must be designated as Roth. If that particular individual who is affected by these final regulations already has an existing Roth deferral, that existing Roth deferral can satisfy this requirement as long as the Roth deferral amount is at least equal to the amount of the catch-up contribution. The plan must offer a Roth catch-up to all eligibles if the plan offers Roth contributions. So let's talk a little bit more about that. First of all, the high earners, these that are identified by the final regulations as earning FICA wages of $145,000 or more for the prior year, these high earners will trigger this Roth catch-up provision. Folks who earn less than $145,000 may still contribute any catch-up contributions on a pre-tax basis. Obviously, the high earners, those who have FICA wages of $145,000 or more, they may contribute regular 401k contributions to a pre-tax savings account. However, any catch-up contributions must fall into the Roth savings account if the plan offers Roth. The plan must provide an effective opportunity for participants to elect pre-tax or Roth where allowed. Let's talk a moment about some of the plan mechanics, as well as some of the deemed elections. So this new requirement of the high earners having their catch-up provisions deferred into a Roth account is satisfied if that participant has already made a designated Roth deferral that is equal to or greater than the catch-up limit. The deemed Roth election allows the plan to automatically treat amounts above the catch-up limit as Roth contributions when a participant elects pre-tax deferrals. The participant must have a choice. Impacted participants must receive an effective opportunity to select a different deferral type if that is allowable under the plan. Also note, employers must update plan documents and summary plan descriptions to reflect these new rules. The super catch-up provisions, that includes those folks who are aged 60 to 63 who are participating in retirement plans. Those participants in a regular 401k or a Roth type of a savings plan may contribute up to 150% of the regular catch-up limit if the plan has adopted the super catch-up provision. Please note, plans are not required to adopt the super catch-up provision, although most plan sponsors have decided to adopt this. In the event that you operate a simple plan, then the 10% increase in catch-up may be replaced with 150% when that benefits the participant. So let's talk a moment about special cases and any type of non-Roth plan requirements. Plans without a Roth program have the ability to cap catch-up contributions at $0 for high earners without violating any type of universal availability. However, non-discrimination testing will still apply. In the event that your plan is a governmental plan, the applicability of these final regulations is delayed until the end of the first regular legislative session, beginning after December 31st, 2025. Participants in Puerto Rico retirement plans are affected under the IRS regulations in that the catch-up contributions satisfy the Roth requirements until local law provides for designated Roth contributions. So let's talk a moment about corrections and transition relief. The 2024-25 transition relief can be described as the following. Catch-up contributions are treated as Roth contributions, even if not designated, which allows time for the systems and the documents to be updated. When determining the amount of the wage of a plan participant, employers may rely on Box 1 of Form W-2 to identify employees who fall above the $145,000 threshold. As far as correction methods, failures can be remedied through W-2 adjustments or an in-plan Roth rollover, generally by the end of the following tax year. And as a reminder, SEP and simple plans are excluded from the Roth catch-up requirement. So what are some action steps for plan participants? I would recommend the following. First, inventory your payroll and your HRIS systems to identify employees now who exceed this wage threshold. And then add or verify Roth catch-up capabilities and ensure the participants can make elections online or via forms with the plan administrator. Decide whether to adopt the super catch-up provision for participants who are age 60 and 63 and ensure that you implement consistently across controlled groups. The next step is to work with your plan record keeper and amend plan documents and update summary plan descriptions on a timely basis. You will also need to craft participant communication explaining these changes. Another recommendation is to develop correction workflows with record keepers to understand how inadvertent pre-tax catch-ups can be corrected. And then the new regulations finally fundamentally reshape catch-up contributions. They compel high earners to save on a Roth basis for those catch-up contributions and introduce an optional super catch-up window, as well as require careful coordination between your payroll system, your HRS system, and your plan administrator. Thank you for joining today. If I may provide you with any additional information, send me an email. My email address is lisa@cummings.law. Thank you so much for joining today. Bye-bye.